Hello everyone. Today we will discuss a very important topic which is information security standards. This covers the 5th unit of your syllabus. So let us start. This is the outline of the unit. We will start with the first topic which is ISO, then IT Act, IPR, Copyright Act, Patent Law, Software License and Semiconductor Law. ISO standards. While information security plays an important role in protecting the data and assets of an organization, we often hear news about security incidents such as defacement of websites, server hacking, and data leakage. Organizations need to be fully aware of the need to devote more resources to the protection of information assets, and information security must become a top concern in both government and businesses. So to address this situation, a number of government and organizations have set up benchmark standards and in some cases legal regulations on information security to help ensure an adequate level of security is maintained, resources are used in the right way, and the best security practices are adopted. Some industries such as banking are regulated and the guidelines or best practices put together as part of these regulations often become a de facto standard among members of these industries. So the International Organization for Standardization, ISO, is a non-governmental international body that collaborates with ICE and ITU on information and communication technology standards. There are various information and communication technology standards. So this is the first one, ISO IEC 27002. This is the code of practice for information security management. This standard contains guidelines and best practices recommendations for certain security domains. Basically, it focuses on security policy, organization of information security, asset management, human resource security, physical and environmental security, communications and operations management, access control, information system acquisition, development and management. These are some of the names. Second one, ISO IEC 27001. This is Information Security Management System requirements. It specifies the requirements for establishing, implementing, operating, monitoring, reviewing, maintaining and improving a documented information security management system. So that will be within an organization and differs from organization to organization. The standard introduces a cyclic model which is known as PDCA, which is Plan, Do, Check, Act. This is a model that aims to establish, implement, monitor and improve the effectiveness of an organization. Third one is ISO IEC 15408. This is evaluation criteria for IT security. So this is commonly known as Common Criteria or CC. It consists of 3 parts. The first one is Introduction and General Model. Second is Security Functional Requirements. And third is Security Assurance Requirements. So this standard evaluates, validates and certify the security assurance of a technology product against a number of factors such as the security functional requirements specified in the standard. The fourth one is ISO IEC 13335. This is IT security management. This was initially a technical report or TR before becoming a full ISO IEC standard. So, it consists of series of guidelines for technical security control measures. These are documents the concepts and models for information and communication technology security management. Then, it documents the techniques for the management of IT security. Third one, it covers the selection of safeguards. And fourth one, it covers management guidance on network security. Second one is the IT Act. This is the Information Technology Act 2000. This is an act of Indian Parliament notified on 17th of October 2000. It is meant to provide legal recognition for transactions carried out by means of electronic data interchange. Cyber laws are contained in this act. This act is to provide the legal infrastructure for e-commerce in India basically. Information Technology Act consisted of 94 sections segregated into 13 chapters. 4 schedules form part of the Act. In the year 2008 version of the Act, there are 124 sections excluding 5 sections that have been omitted from the earlier version and 14 chapters. Schedule 1 and Schedule 2 have been replaced and Schedule 3 and Schedule 4 are deleted. The Information Technology Act addresses certain important issues. They are legal recognition of electronic documents, legal recognition of digital signatures, offences and contraventions, and justice dispensation systems for cybercrimes. These are some of the objectives of IT Act. To grant legal recognition for transactions, then to give legal recognition to digital signatures for authentication purposes, facilitate electronic filling of documents with the departments of the government. Also, electronic storage of data is facilitated. Legal sanction to electronic fund transfers is facilitated. And keeping records of the book accounts by the bankers in electronic form is also facilitated. Next is Intellectual Property Rights or IPR. So, intellectual property rights are the rights given to a person or an organization for their intellectual property. That is their innovations that has grown up in their minds. Some of the benefits of intellectual property rights are encourage innovation, sharing of knowledge, and also protecting the creator of the knowledge, allowing the work to be developed in a more proper manner, and allow commercial return, and also allow the work to be used in public sphere. IPR is divided into 7 main branches under trade related aspects of IPR. So, patents. Patent is an exclusive right granted for an invention which is a product or a process that provides a new way of choosing something or offers a new technical solution to a problem. It is a government issued right granted to individuals or groups that protects their original inventions from being made, used or sold by others without their permission for a set of period of time. Okay. Copyright, second one. Copyright is a legal concept actually enacted by most governments, giving the creator of original work exclusive rights to it, usually for a limited time. Generally, it is the right to copy, but also gives the copyright holder the right to be credited for the work to determine who may adapt the work to other forms. Copyright materials may include certain creative works that can be a part of literature, art, music, or can be technology based like computer programs, electronic databases, to name a few. Third one is trademark. Trademark are the characteristic distinguishing signs, symbols, or indicators used by the individual or any organization, which are normally used to recognize a particular service, which specifies its source to differentiate its services from other organizations. Okay, so we can say that trademark is a recognizable sign or maybe designer expression which identifies products and services. A trademark may be located on a package, a label, a voucher, or on the product itself. Next one is copyright law. So, a copyright law protects the tangible expression of ideas. It confers on the copyright holder the exclusive right to copy, adapt, distribute, and perform that material. Okay. There are some main forms of remedies in the event that copyright infringement takes place. It can be an injunction to stop the production of further copies, a demand that all copies are surrendered to the copyright owner, damage for the losses suffered by the copyright owner, or an account of profiles may be infringer. Some examples of original works of authorship where copyright can be implemented can be literary works, musical works, dramatic works, pictorial, graphics and sculptural works, sound recordings, to name a few. Next one is patent law. So, a patent law can be defined as a grant of exclusive right of the inventor over his invention for a limited period of time. Patent law is the area of law that relates to IPR, intellectual property rights, discussed already. These are also known as patent rights, and they are used to protect the rights of a group of individuals over their own original inventions. Patent laws cover the regulation and enforcement of these intellectual property rights. The patent laws prevents anyone other than the holder of the patent from making use of the protected idea without obtaining permission from the patent holder, of course. If someone tries to use the patented idea illegally, then the patent laws specify the legal action that the patent holder can take against them. So, some of the advantages of patents law is that the patent owner holds the exclusive right to the invention and that others must pay a license fee to obtain that right. Additionally, a company may invent something that is not necessarily useful to the company's overall goals at a time, and then they would have to decide whether the lengthy and sometimes expensive patent application process is in the best interest. Next, we move on to the topic which is software license. So, a software license is the right to use a particular software package within the term established by the vendor. By buying a software license differs in several ways from buying a packaged product. When we buy a retail version of a software package, the cost includes three components: the license, the installation media, and the manual. Software licenses only acquire the right to use the software, and the cost generally reflects this. Semiconductor law. The layout design of a semiconductor integrated circuit refers to a layout of transistors and other circuitry elements which are connected through lead wires. the intellectual property rights in the field of semiconductor integrated circuit layout design are protected by the Semiconductor Integrated Circuit Layout Design, which is SICLD Act 2000. The main features of SICLD Act 2000 can be summarized as the act is applicable to the whole of India. The layout design of the integrated circuit chips are to be registered with the SICLD registry for availing IPR protection. The list layout design of integrated circuits which can be registered with it. It defines the duration for which the registration of layout design is valid. So these are some of the important features of SICLD Act 2000. So this is all that I had to discuss in this chapter. Thank you.